And good morning, Your Honor. Nicole James, appearing on behalf of Misa Parker.
All right.
This courtroom session wastes no time, and neither should you. What you're about to witness isn't just routine legal procedure. It's a chain reaction of decisions that can instantly change someone's life. From missed court appearances to waived rights to defendants clashing with their own attorneys, every moment here carries consequences most people don't fully understand. Right at the start, we're dealing with a defendant who's not even present. That might sound minor, but in the legal world, failing to appear is one of the fastest ways to escalate your situation from manageable to dangerous. Judges don't just see absence. They see risk, disrespect for the court, and potential flight. Then we shift into multiple cases, each with different stakes. Waiving a preliminary exam, competency evaluations, and eventually, yes, a heated breakdown between a defendant and his legal counsel. In that last one, that's where things get explosive. Because when a defendant stops trusting their own attorney, the entire defense strategy starts to crack. Watch closely. Pay attention to how the judge reacts, how attorneys frame their arguments, and how quickly control can shift inside a courtroom. Because by the end of this session, you'll see exactly how one decision or one misunderstanding can spiral into something much bigger.
And Mr. Parker, or Miss Parker?
Mrs. Parker, yes. Ms. Parker.
Miss Parker, are you here?
Yeah.
Uh-oh.
I thought she was here.
Yeah, me too.
Judge, can we recall her case?
Pardon?
I'm sorry, Judge, you were talking to me?
Yeah, what did you ask?
Can we recall it? I've spoken with her. Please.
Why isn't she here?
Judge, I'm not sure, but I spoke with her yesterday, and she knew to
Here's
be.
what happened. Bench warrant will issue for defendant's failure to appear. If you can get her here before it goes down the hallway, then maybe I'll call it back. Maybe I won't. I don't know yet.
Fair enough.
All right?
Okay.
Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Ms. Parker, you need to log in.
All right. Thank you. She's on the
Thank
phone.
you, Your Honor.
Hurry up. Rush that down the hall. No. Court calls the case. People versus Douglas Hill.
I didn't go.
Kermadadish on behalf of the people.
Again, good morning, Your Honor. Nicole James, appearing on behalf of Mr. Hill.
Mr. Hill, can you state your name, please, sir?
Douglas Hill.
All right. He's here. All right. What are we doing?
Judge, I've had an opportunity to speak with Mr. Hill regarding his right to have a preliminary examination and what the people must show he wishes to waive his preliminary examination and be bound over to circuit court.
This is a critical legal move, and most viewers won't realize how significant it is. A preliminary examination is one of the defendant's first real chances to challenge the prosecution's case. It forces the state to show probable cause, to prove that a crime likely occurred and that the defendant is connected to it. By waiving it, Mr. Hill is essentially saying, I'm not going to fight this here. I'll deal with it later in circuit court. Now, that can be strategic. Sometimes defense attorneys waive prelim exams to avoid revealing their strategy too early, or because they believe the case will be resolved through negotiation. But it also means giving up an opportunity to test the strength of the prosecution's evidence. So the question becomes, is this a calculated move or a missed opportunity? Because once you move to circuit court, the stakes increase. The charges are locked in, and the process becomes more formal and often more difficult to navigate.
All right. Is that correct, Mr. Hill?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
All right. You understand you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, 4, with 5 and 6 following. Ms. James.
Judge, as to the arraignment on the information we waive from a reading and standing.
Defendant having waived formal reading, standing mute. So all 6 charges, court will enter a not guilty plea. Pretrial will be set for
June 22nd, 1:30 p.m. Judge O'Brien.
June 22nd, 2023, 1:30 before Judge O'Brien.
Thank you, Your Honor.
Thank you. Bond continued. Case People versus William Matthews.
We're ready in that matter, Your Honor.
Laura Willenberg on behalf of the people.
Senator Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. William Matthews Jr. Mr. William Matthews, please state your name for the record.
William Herman Matthews Jr.
Your Honor, today is the date. I'm sorry.
Go ahead. No, go ahead, sir.
Today is the date and time set for the probable cause purpose. Based on my conversations with both Mr. Matthews and Mr. Gaddy, we feel that at this time it is appropriate to refer Mr. Matthews for both competency and criminal responsibility.
Now, this is where the legal system shifts from procedure to psychology. When a defendant is referred for competency and criminal responsibility evaluations, the court is asking two very specific questions. First, is this person mentally capable of understanding the charges and assisting in their own defense? That's competency. Second, at the time of the alleged crime, were they mentally responsible for their actions? That's criminal responsibility. These are not small questions. If someone is found incompetent, the case can be paused entirely. If they're found not criminally responsible, it can change the entire outcome, from prison to psychiatric treatment. And notice how smoothly this is handled. No drama, no argument, just process. That's because these evaluations are often based on prior conversations, behavioral indicators, or concerns raised by counsel. This is one of those moments where the courtroom slows down, but the implications become much deeper.
And I do have the orders. I've signed both of those orders. I'll set a competency hearing date.
August 10th.
I'll set a competency hearing date for August 10th, 2023, 9 a.m.
Thank you, Your Honor.
Thank you. Bond in this matter will continue.
Thank you.
Thank you. Court does call the case of the People versus Virgil Ross.
We're ready in that matter.
Well, hold on a moment. Go ahead.
Alex Jablowski on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Virgil Ross. Mr. Ross, please state your name for the record.
Virgil James Ross.
You know, hold on one more. Yes, this is the one.
He had two cases.
Oh, he's got two.
I didn't realize that. So this is not the one that you adjourned. That one did get adjourned.
Oh, that other one got adjourned. This is, okay, I was not aware of that. Okay. All right, what are we doing in this case of his?
Your Honor, before we get started, I believe Mr. Ross would like to address the court.
Mr. Ross.
Yes, Your Honor, there's a breakdown in communication between me and my current counsel, as well as the public defender office. At my arraignment, I was denied bond. The arraignment was for an alleged bank robbery charge, and the public defender used MCR 6-106B to deny me bond, based on his rules stating that I've been convicted.
This is where the tension spikes, and it's not between the defendant and the prosecution. It's between the defendant and his own defense team. What Mr. Ross is describing is a breakdown in communication, which in legal terms can sometimes justify replacing counsel, but only if it meets a very high threshold. Courts don't allow attorney swaps just because of disagreement. There has to be a serious issue affecting the ability to mount a defense. He's raising concerns about bond denial, incorrect criminal history, lack of discovery, and poor communication. These are heavy claims. If true, they could impact due process. But here's the problem. The court doesn't rely on feelings. It relies on evidence and procedure. And the judge is already signaling skepticism. You can hear it in the interruptions and the tone. Who do you think is in the right here? Is this a defendant being ignored, or someone trying to control their case without fully understanding the system? Because in court, perception matters, but proof matters more.
Oh, the public defender did that?
Yes, and not Mr. Lauren Brown, but the public defender's office, that the public defender that was assigned to me did that. And based on that,
denied you bond?
The magistrate denied bond after they used the Michigan court rules, sir. Okay, so after that happened, stating that I've been convicted of 2 or more violent felonies in 15 years, and this was not true. The public defender failed to just simply look on MDOC Otis and seeing that I only had 1 violent crime. Also, with my current and present counsel, I haven't been able to put any input or assist in my own defense. I requested motions for discovery and full disclosure, and as well as the custody order. And neither one of these motions are privileged. Also, I've asked for any type of paperwork concerning my case. And just until 36 hours ago, I was just notified that the 3rd degree home invasion charge was changed to B&E. That's part of the breakdown in the communication.
I don't know that, sir. Go ahead. I'll let you finish.
Yes, and I understand and comprehend that I'm not entitled to have the attorney of my choice, but also I'm unfortunately indigent and I can't afford to retain counsel. But the Michigan Constitution, United States Constitution said I have a due process right to have assistance of counsel. So I believe that there's good cause that exists where there's clearly a difference of opinion between me and my current attorney. I believe that I should have.
And so your current attorney, the one with the law degree, you have a difference of opinion. Yes. I just want to get this right. Oh, yes, okay. Sir. Go ahead. Yes. Go ahead then.
And I mean, the difference of opinion is I believe that I should be able to assist my counsel in my own defense. And even though it's early, I believe that this agreement has caused a fundamental trial tactic as well as a meaningful defense that in near the future. And I'm just respectfully asking that my current counsel be replaced immediately.
Did your current counsel be what?
Replaced immediately.
Yeah, okay. What date did we set that one?
Your Honor.
I sent you a letter requesting this.
22nd? Okay. Yeah, Mr. Brown, go ahead if you want to respond before I do. I just want to, I don't know if Mr. Ross even knows this. He's got another case before me that your counsel's filed a motion to protect your interest in the case. And the court has already gotten a prosecutor's response and we've set it for hearing. So that's interesting, these people not working for you. But go ahead, Mr. Brown, go.
What if they're not working? I didn't say they wasn't working.
You know what? You know what? I didn't say you. I said Mr. Brown can go ahead. Mr. Brown.
Thank you, Your Honor. Your Honor, the court should be aware that we put several man hours into this. We've had investigators going across downtown Ann Arbor seeking evidence and information on this case. I've spoken with Mr. Ross several times, twice visited him, spoken to him by phone, and spoken to him with a video conference. Mr. Ross believes that he cannot work with our office, and his belief is affecting our ability to be able to work for him in a zealous manner. So we are working for Mr. Ross. He doesn't believe that's the case, but I think that belief is the real thing here. That's going to cause a problem with our continuing to be able to zealously represent him, as he feels that his opinion on how things should be done is, if not superior, at least equal to ours. So that's all I'm going to say on it.
Mr. Ross, anything else you want to say?
Yes, I just believe that there's no transparency between me and my attorney. I believe that I should have my discovery. I believe I should have my police reports. I have none of these things. And I've been in this county jail for 5 months. Also, I should have been notified earlier of the charge being changed from a home invasion to a 3rd degree. So that in itself,
well, I don't know why you're in. Why were you in there 5 months?
This case, 5 weeks, sir.
You were 5 weeks. 5 weeks. Okay.
I haven't got not one piece of paper from the public defender's office concerning either charge.
So let's see. I don't have his bond as denied in this case. Is it the other case that it's denied?
In the bank robbery, yes.
Yeah, that's not before me today.
Yes, it is, sir. How is not? I got 2 cases.
Why? What? Hold on a minute. You're going to tell your attorney what to do, and then you're going to tell me what to do.
I'm not telling nobody
or what I have.
You should have 2 cases. You have 2
Listen
cases.
to me. That case, your counsel filed a motion to protect your interests. I just said it to you. The problem that you're having is you're not listening. Mr. Brown filed a very detailed motion with this court that this court reviewed, requested a response from the prosecutor.
This is the turning point, and the judge makes it very clear. The issue, from his perspective, isn't lack of representation. It's lack of cooperation. He lays out the facts. The attorney filed motions, the court reviewed them, the prosecutor responded, and a hearing was already scheduled. In other words, the system is working, but the defendant isn't aligned with it. This is a common but dangerous situation. When a defendant believes they know better than their legal counsel, it creates friction that can weaken the defense. Attorneys operate within legal strategy, timelines, and procedural rules. Defendants often operate on urgency and personal frustration. The judge's decision to deny the request for new counsel is based on this principle. Disagreement alone is not enough. And now, instead of solving the issue, the court consolidates both cases, raising the stakes even higher.
The prosecutor filed their response. This court immediately set that case because of partially the bond and the issue that Mr. Brown brought before the court. I set that case for hearing. What day, Miss?
The 22nd.
The 22nd at 2 p.m. So, sir, no, that case is not before me today.
So, Your Honor, what I'm saying
Are
is
we
you have
understood?
any of this information. I don't know any of this. I haven't seen the motion.
Well, now you do.
It's horrible.
Here's what we'll do. We'll just make this easy for everybody. What time is that other one set?
2 p.m.
2 p.m.? All right. Court is going to find good cause to adjourn the probable cause conference in this manner. I will adjourn it 1 week out so that both of his cases can go together and he can still have his complaint, I guess, that he has. And maybe if he'd listened to his attorneys, he won't have the complaint. But I'll let him do what he's going to do. I'll adjourn it to June 22nd, 2023, 9 a.m. Motion. All right. See? Okay, why don't we do this? If he wants to play it that way, we'll just make both those hearings in person. Because if he wants to play that way, Mr. Brown, what do you want me to do with that?
Your Honor, I will leave this completely in the court's discretion. Absolutely.
Okay, let's bring him up. I'll set that in person. That's at 2 p.m. on the 22nd, and we'll see how he wants to act that day. His request for withdrawal of counsel, denied. Bond continued. Thank you. Now you're done and can leave. Court calls the case. People versus Maurice Robinson.
Court will bring on behalf of the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Robinson. Mr. Robinson, would you please state your name for the record?
Maurice Robinson.
You got something to say, Mr. Robinson? No, I'm kidding. I'm just messing with you.
No.
Go ahead.
I'm certain that Mr. Robinson has nothing to say right now. Isn't that correct, sir?
All right, very good.
So, Your Honor.
This courtroom session closes with a clear message. The system prioritizes structure, not emotion. Across multiple cases, we saw how quickly outcomes are shaped by decisions, showing up late, waiving rights, questioning counsel, or misunderstanding procedure. In the first case, a simple absence led to a warrant and a $10,000 bond. In the second, a strategic waiver pushed the case into a higher court. In the third, mental evaluations introduced a completely different legal pathway. And in the final case, a breakdown in trust between a defendant and his attorney resulted in the court stepping in and refusing to reset the process. Judge Simpson maintained control throughout, focusing on efficiency, legal standards, and procedural fairness. Whether the defendants agreed or not, the rulings were grounded in how the system is designed to function. And that's the real takeaway. Courtrooms don't operate on what feels right. They operate on what can be proven, processed, and justified under the law. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.